All right, so today we will continue with institution of suits. How suits can be instituted. Now, when there is a civil matter which is filed, right, we call it as a civil suit. Now, we know that CPC provides for the rules or the process that we need to follow for filing of a suit. So how is it that we will institute a suit? How will a suit actually start? How we will file it before the court? That's what this topic is all about. Now, as we have already discussed that in IPC, we have some sections which provides for, like in general, it talks about what things are there. And we have then our orders or our different rules, which provides for the actual process, how it will happen. Okay, now in this, with this example, right, you will be able to understand the difference between sections and the orders which we have. So orders, in a more elaborate way, they provide for the rules and regulations that we need to follow. Just like how in the main body we have sections, same ways in case of orders we have rules. Okay, it's not called as sections, they are called as rules, like rule 1, rule 2, rule 3, like that there will be different rules. So this is like the main body of the code where we have different parts. Under that we have different sections, but for orders we have different rules. Okay, like 1, 2, 3, 4, and it will not like continue like 158 sections we have, but for rules, rules will start with number 1 for all the different orders. Okay, like for order 1 it will start with 1, for order 2 also it will start with 1, like that. Okay. Now, institution of suit. When we use this word suit, what is a suit? CPC provides for a lot of different words definitions, right? It defines judgment, foreign judgment, so many words are being defined. But then CPC do not define what a suit is. Okay, in 2 of the decisions of courts, court has said that suit basically means civil proceedings instituted by presentment of a plaint. That means whatever civil proceedings we initiate or institute in the court, those are considered as suits. And we have one legislation, first class we discussed, right? Substantive and procedural. And procedural, apart from CPC, CRPC, Evidence Act, we also have one legislation called Limitation Act. Do you remember what Limitation Act is all about?
Like you had mentioned about we can file a case for a particular like consider there is a missing person. Okay, we can file a case within so many years.
Yes.
That is one example.
Yeah.
There will be some limitations or conditions within which the case needs to be filed in the court.
Yes, there will be some time limit within which we need to file the case in the court. So this Limitation Act also provides for definition of certain words. There in section 2 clause small l, okay, 2 clause l, it provides for definition of the term suit, and it says suit does not include an appeal or an application. Okay, an application filed before the court, that is not a suit, plus a civil appeal or first appeal, second appeal, those are also not considered as a suit. They are considered as civil matters, civil appeal, civil whatever it is. Okay, but those are not suits. So suits would basically mean the original suit that you are filing before the court. Okay, by presenting a plaint what you are doing. That is what suit is. Now, when we talk about suits, there are 4 essentials which are needed in a suit. Okay, when we are filing a suit before the court, there are these 4 things which are needed. What are these 4 things? First of all, there has to be an opposing party. Whenever a case is filed before the court, it's always someone versus another, right? There will always be this versus that. That means there are 2 parties. There is a dispute between them. There are certain things which need to be settled. And that's the reason why they have approached the court. So there will always be one opposing party. If I'm approaching the court, there has to be someone against whom I'm going to the court. Okay, it cannot be like me versus me. It has to be someone else, opposing party. Now, when we say two parties, it's not always necessary that it has to be like human beings only. Okay, in law we call as, wait 1 second, I'll just write it. So juristic person, first of all, opposing party, like whenever a case is filed before the court, right? This word person is having different meaning in law. Otherwise, we understand it's a human being, living human being like you or me. But in law, this word has a broader meaning. It includes a juristic or an artificial person also. Okay, who is a juristic or artificial person? Any idea? Natural human being, we know, right? That we
Right,
have.
yeah.
Yeah. So artificial person basically means artificial or juristic person. That means only in the eyes of law, they are considered as a person, not otherwise. Why? Because it's very much, it makes it entire thing convenient. Okay, like take for example, there is a college, there is a newspaper publishing agency, there is some company, organization. All right, we can file a case against them also as a body corporate, or they can also file a case. Okay, like the company, in the name of company also a case can be filed. We don't need to mention the directors or the CEO there. It is completely fine. That body will be called as a juristic person. Only in the eyes of law, they are considered as a person, juristic or artificial person. So first thing that we need is opposing party. There has to be two parties, one going to the court, another one against whom the person is going. It may either be natural human being or a juristic person. Second is subject matter. Okay, whatever is the matter, there has to be a subject for it, right? It may be either that there is a contract between you and me, and I did not fulfill the contract. I did not fulfill the promise which was made in the contract. That means what is the subject matter? It is breach of contract. There might be another case wherein someone borrowed money from you and the person is not returning. It would be recovery of money, right? So like that, there will be different subject matters under which the case will fall, under which the suit would fall. That is the second element which we need. Third is cause of action. Cause of action means the main reason why I'm approaching the court. I cannot randomly approach the court and file a case. There has to be some cause of action. So what may be cause of action? If there is a contract between you and me, and if I violated the contract, I said I'm not going to perform the contract, cause of action will be that thing, that my breach of contract, that I said that I'm not going to perform it, that will be cause of action. That is the main reason from where you got your right to approach the court. Okay, so cause of action has to be a valid cause. It has to be a valid or strong enough reason that court would accept. Otherwise, court would simply say that there is no sufficient cause of action. This matter is dismissed. We are not entertaining this matter because party has simply approached the court. There is no proper cause of action. Okay, so cause of action is also very much important, which simply means the main reason why party approached the court.
Okay.
So cause of action means the main reason why party approached the court. And last but not the least, relief. So what is relief? Relief. Have you got this before?
Is it same as remedy?
Yeah, like remedy only, relief. Because when we are approaching the court, we will have something in our mind, right? Might be you want that whatever contract was entered, that contract should be performed. Or you might want that, okay, fine, it's fine, even if contract is not being performed, I should get compensation. You may want injunction order, whatever it is, right? It's same like remedy. You would ask for some remedy or some relief, that also has to be there. So these are the 4 essential things that we need. There will be 2 parties, one going to the court against another. There will be some subject matter under which it will fall. There has to be a proper and valid cause of action, and fourthly, remedy or a relief which the parties will claim for. Okay, so these are main essential things in a suit which is being instituted in the court. Now, when we talk about institution of suits, we have section 26 of CPC. Okay, section 26 makes a provision. Now, if we look at here, section 26, it is institution of suit. Okay, institution of suit. And if we look at the provision here, yeah, so this is what it says mainly. Section 26, every suit shall be instituted by presentation of a plaint or in such other manner as may be prescribed. In every plaint, facts shall be proved by affidavit, provided that such an affidavit shall be in the form and manner prescribed in Order 6, Rule 15A. That means it simply is giving you a right that if something has happened, you have a right to institute a suit. How we will institute a suit? You will simply present a plea and you will institute the suit. But then, what are the detailed rules that you need to follow? Those rules will be given in orders. That is why here also it is written that in the manner as prescribed under order. That means orders are clearly giving you instructions. Okay, how you need to do it, what you need to do. Like same ways, even if we apply for some exam, right, for your semester exam only, might be a notification will come wherein simply it will be mentioned that pay this much of fees within this date, download the hall ticket, and it's done. But how you need to do it, entire detailed process, you would get details from the might be admin department of the university, right? So admin department is nothing but this order who will tell you go to this counter, stand in this queue, deposit this, do that, or everything will be given. Same ways, in case of CPC also, orders will give us the details, how we need to do, how we need to fill the form, which form we should be filling. Every single detail will be there in the order. So this is what from sections part, if you talk, section 26 is the only section which talks about institution of suits. It is this simple, very simple, just 3 subclauses, 2 subclauses, and this is what it is all about. But then we need some additional information also. Those additional information are given in orders. Okay, so section 26 and order 4. Okay, sections and orders, we need to read it like combined. Okay, because they are related again. All right, so section 26, order 4 provides for institution of suit. Order 4 is also about institution of suit only. Section 26 lays down that every suit shall be presented, whatever we read basically, that is what again it is explained. So section 26 and order 4 provides for institution of suit. Plus, this section must be read along with order 4, order 6, and order 7 of first schedule. Okay, when we talk about orders, there are 3 orders which become very much important for institution of a suit. Now, what are these 3 orders all about? First one, order 4, talks about institution of suit. Secondly, next order talks about pleadings generally. Next order talks about plaint. So all these 3 orders are very much important. Like I said, in each order, there will be different rules. Okay, so what are orders basically? It is nothing but just like how we have different parts. right? In this main CPC, different parts are there. Each part is talking about different thing. Same ways you can consider there are orders talking about different things. In each order, there will be some rules also. In place of sections, we have rules over there. Okay, so these are the three important orders that we need to read: institution of suit, pleadings generally, and plaint.
Yeah. Why they are called as orders? Like, has it come from any judgment or?
Which one?
Like usually orders we relate with judgment,
No,
right?
no, no.
For any, or it is nothing to do with.
No, no,
Okay.
nothing to do like that.
Okay. Okay.
Whatever, basically whatever from judgment it comes, right? We say that, okay, it's like a precedent or some guidelines were being issued, like that only we call. Order as in complete, like order when we are referring, that we mean. So this has got nothing to do with that.
Orders are nothing but it is set of rules.
For CPC, yeah, it is like set of rules, correct.
Okay.
So order 4, it is having only 2 rules, okay, and both these rules are important. For order 6 and 7, there are few rules which are important. Otherwise, everything you don't need to read basically. Okay, so for order 4, rule 1 talks about suit to be commenced by plaint. So every suit that you want to institute, how it will start? It will start with presentation of a plaint. So once a matter has taken place, once there was a contract, I violated the contract, there is breach of contract, and you know that it is a valid cause of action. You have a right to go to the court, claim for a relief. In such a case, you would not randomly run to a court and then, like start complaining about me. You cannot do that. You need to do it through a process, through a procedure. That procedure is given in CPC. So what is the process or procedure how you will approach the court? You will institute it by presentation of a plaint. So what is a plaint? You will mainly write your matter, okay? Whatever has happened, you will write it in detail. Like if you are reading a case also, you will get the details, right? That this happened on this date, it happened, like that happened, this the parties did. Have you seen any case such like that in Indian Kanun or somewhere?
Yes, yeah.
You have seen it. So starting off the part, it will just explain the story, what happened on that specific date, right?
Yeah,
So
a
that
brief
is
fact.
brief fact.
Yeah.
Correct. So brief fact of what happened on that specific day or during those days. That is nothing but what will be written in the plaint. Simply explaining the story. Okay, in duplicate or in other manner prescribed by the code of CPC. So if there is like a proper manner prescribed, in that way it has to be, or whatever is the manner applicable. Okay, like we have basically different formats for different types of suits, so that format has to be followed, and in that format parties will write or narrate the entire story, because we cannot simply go to the court and start complaining about a certain thing.
Okay, it is like a kind of template we have to follow.
Yeah, it's sort of a template, like same format is usually followed.
Yeah.
Okay, every plaint shall comply with the rules contained in order 6 and 7. So first order 4, it says, okay, institution of suit, but to know in detail about the process, we need to refer these two orders also, order 6 and 7, so far as they are applicable. As I mentioned, in 6 and 7, there are a lot of rules mentioned. All the rules might be relating to different types of suits. So whatever rules are relevant for you, those rules you need to follow from order 6 and 7 also. And in that way, you need to prepare your plaint. In that way, you need to write down your entire story. Okay, the plaint shall not be deemed to be duly instituted unless it complies with 2 requirements. That is, institution of a suit by presentation of a plaint, and plaint shall comply with all these orders. That means even if you have, might be, I can simply randomly write my entire story in frustration and just submit it in the court. but that will not be considered as institution of suit. Okay, the plaint shall not be deemed to be duly instituted. Even if I'm submitting something in the court, that random letter or complaint thing, what I have written, it will not be considered unless and until institution of suit by presentation of a plaint. If I have not submitted my plaint, if I have simply might be something printed, I have given some random things, that is not enough. I should give a proper plaint, plus it should fulfill whatever things are mentioned in order 6 and 7. Only in that case, it will be considered that yes, there is institution of suit. It is duly instituted. Okay, so that is nothing but rule 1. So see, orders are providing so much of detail, right? That you need to write it in this given format, this rule, that rule you need to follow. But section, it just randomly said that, okay, institute a suit. So that's the basic difference between order and section. Okay, rule 2 talks about register of suits. Now, in a single year, there will be a lot of cases filed before the same court. Okay, and after 10-15 years, if we want to get some copies of that case, if we want to know what happened in that particular case, it would be very difficult for us to get the information. That's why cases are numbered. Okay, you would get some case number and of this certain year. Have you seen this first page of plaint in any case?
Yes, yes, yeah.
You have seen, right? So there will be one given number, and there will be some CIN number also. With that number, you can actually get all the details, and you can visit this eCourt website. There, what happens, right?
Okay.
So if you open this eCourt, so see here, we need to add 16-digit CNR number. So we get a CNR number for each case, where you would also, by looking at the CNR number, right, you can also say from which state the case belongs. Like it would be KA, MH, like that it would start. Once you put that number here and you put this captcha, you would be directed to that page where you will see whether case is disposed, whether the case is pending, what was the order passed in that case, every single detail you will get.
Okay. It can be any court, high court or supreme
Even
court.
for high courts also we have. One second, I'll show
High
you.
court I had seen by visiting the high court website itself.
Okay. Yeah, high court you have seen.
This e-court is common for all the courts.
Yeah, e-court is common for all the district and taluka courts of India. For high courts also, we have another similar thing. So this is what we have for high courts. Here also we have different high courts, or you can even go to specific high courts, and there also you get the option of seeing the details of cases. So take for example, this is a CNR number which I have, and then I will put this one here, search, and then I will get all the details. See, criminal case, it is case is disposed of. Okay, what is the matter of disposal, like reason of disposal? He pleaded guilty, uncontested, right? So you would also get the section, IPC, it was rash driving case. Then you get orders also, what happened in this. That means it has become, because of this e-court thing, right, it has become very much convenient for us to get these details also. It's in Kannada, but yeah, still. Accused is present, pleaded guilty, he is convicted, hence case is closed. So like that, we get to know the details as well. Okay, so all those details, it becomes easier because of this numbering which is being done. So there will be one register of suits. So every case will be numbered in every year. So there will be year like 1 of 2021, 2 of 2021, 3 of 2021. Same ways, this for like case type also, there are certain abbreviations which are used. Okay, like is it original suit, OS, money suit, MS, like that it will be mentioned. Okay, motor accident claim, MACT, like that's, there are some like abbreviations used by them also. So this is nothing but rule 2, register of suits. So every suit shall be entered in a book, which is called as Register of Civil Suits, and entries will also accordingly be made, numbers will be given over there. So see, there are this appendix, right? Appendix are nothing but providing for certain formats. So usually they will just leave a space blank when it is typed. They will leave a space blank and then court will add some number in a handwritten format. That is nothing but they have registered the suit. They have been given a number to it. So these are the two rules which we have in order 4 of CPC. Okay, that talks about suits, how it has to be instituted, institution of suits. Now, there are 2 more orders where a lot of rules are given. Some rules are very important. That part we will be seeing. Okay, this is clear, right?
Yes, ma'am. Yeah.
Okay. Order 6 is pleadings generally. So what is pleading basically? When we are presenting a case before the court, the plaintiff, right, that person will write his own side of story, that is called as plaint, and the other side also will write, that is written statement. So it is called as pleading. Okay, it may either be plaint or a written statement, whatever it is. Now, pleading to state material facts and not evidence. Pleading whatever we submit before the court to narrate our story. It is only for the court to get the idea, right? What happened in the situation? What is the situation all about? Just to get an idea on that, we are submitting it. So we don't need to mention this evidences. We don't need to mention that, okay, this party had done this, so this is the evidence I have available. By presenting it in this way, I can establish my fact. Those things are not needed. Simply in a very like in a very detailed way, we need to explain the story on what happened, what are the material facts, whatever is relevant for the courts to know, that we will mention. So pleading shall only contain a statement in a concise form of the material facts on which the party's pleading relies. Whatever relief I am claiming, based on what reason I am claiming it, what is my action, cause of action, that thing I will mention in a proper way with all the material facts. Evidences on which the parties are willing to rely to prove their point, it need not be mentioned in the pleading, because there will be time when I will get the opportunity of producing those evidences establishing my point. Now, I just want to give an idea to the court on what has happened. Whenever necessary. Now, while writing one story, right, it's fine if it has happened in one day story we are writing. Sometimes it may be a story of like generations altogether. This happened at the stage of great grandfather, this happened at the stage of grandfather, father, son, like that. There is like an entire very broad detailed story. This happened, that happened, so many parties involved and everything. It may become very much confusing, and when everything is just dumped in one paper, we don't even feel like reading it. Okay, so whenever necessary, pleading shall be divided into paragraphs. Properly we should be writing it so that the party is also able to read it, understand it properly, able to differentiate between the things. And it has to be properly numbered also whenever necessary. If there are 2 or more allegations, such allegations need to be mentioned in separate paragraphs so that we don't mix everything. We are able to understand, we are able to differentiate between the 2 allegations, 3 allegations which are made in the pleading. If there are any dates, sums, numbers which are mentioned, it has to be written, plus it has to be in like words as well as figures, just to avoid any sort of confusion. Everything has to be given in that way.
And there is no rule saying that only the advocate should file the suit, right? It can be even
Yeah,
an
it
ordinary,
can be. Yeah, it can be the
ordinary citizen.
person also, it can be the advocate also. Yeah. Rule 3 talks about forms of pleading. So there are forms being provided, but again, there are so many different types of cases that take place. So sometimes a form on that specific type of case might not be available. So if available from Appendix A, we will take that specific form in that proper way we will fill. If not available, then whatever, like similar sort of whatever we are getting, that we will do, and we will just fill it in detail. In case of commercial courts, usually these are filed before High Court also. So whatever format, if High Court has provided some format, some template is there, in that ways it has to be filed. Okay, basically if there is a format, follow that. If not, some similar things you can follow to write it. Now, no pleading shall, except by way of amendment, raise any new grounds of claim or contain any allegation of fact which are inconsistent with. Now, I'm submitting a plaint. I have written my entire story. But now I feel that there are few more things which I want to mention. Few more allegations are there. In such cases, if I want to make the changes, it has to be by way of amendment only. I cannot go to the court and say, give me this previous plaint which I had submitted and take this new one, because it will just be changed, right? Everything will be changed and the party would be, it would create confusion. So if I want to make any changes, I can do it by way of amendment only. So the previous copy is also there. Plus there is a record in the court that there has been amendments which are being made in this certain case.
Okay.
Okay.
Again, it has to be followed in the same format.
Yeah.
Okay.
Next is pleading to be signed. Now I will write a lot of things. I will submit it before court, and based on that only the case would be instituted, right? So it has to be also ensured that at a later stage, I don't disagree. I don't say that, okay, I have not filed this case or something, right? So pleading to be signed. Every pleading shall be signed by the party and his pleader, if any. So this is what you were asking, right? Is it necessary to hire? So if any, that means it's not necessary. So if there is a pleader, it has to be signed. Otherwise, the party has to sign it, because we want to ensure that at a later stage, the party don't simply say, after wasting a lot of time, party don't simply say that I never filed the case. Sometimes because of some valid reasons, if party is not able to sign the pleading, it may be signed by any person who is duly authorized by him to sign on the same. So if someone other is there who is authorized, that person can also sign. Or it may even be like a legal representative sort of thing also, who can initiate the matter. Now, address of service of notice. Once the case starts, right, there may be certain notices which the court would be willing to send to parties. So it is very much necessary that parties also mention their address, provide their address, so that notices would reach to the party. So every pleading, when filed by a party, shall be accompanied by a statement in the prescribed form, signed as provided in Rule 14, regarding the address of the parties. So we need to also mention that this is my registered address. Okay, it has to be signed either by the party and the pleader, either by the party only, or by some legal representative or someone. It has to be signed that this is what my registered address is where notices may be sent by the court. Now, because cases go on for years altogether, it is like quite obvious that parties may change their addresses. Party may not be available in the same old address. In such cases, from time to time, it may be changed also by lodging in court a form duly filled up and stating the new address of the party, accompanied by a verified petition. So the party can provide that this is what my current address is going to be from so and so date, and it can be submitted also. Whatever address we have mentioned at the first place or after making some changes, it will be considered as registered address of the party. And it would be deemed to be address of the party for the purpose of service of all the processes in the suit, or any appeal from any decree, order, thereby whatever things need to be sent, it will be sent in that certain registered address only, which is mentioned in that form, or at the initial stage only in the plaint, whatever is mentioned, that will be recorded as registered address of the party. Service of any process may be effected upon a party at this address in all respects as though such party resided there. So it would be considered that the party is available there, it will be sent to that certain place only. Okay, and it is also very much necessary whenever they are changing it, that time also it should be signed by the party, or whoever is the legal representative or representing the party, it has to be signed by them. So that was on the plaint which is being submitted, then changes in terms of address. Okay, now there is another rule, Rule 17, which talks about amendment of pleadings. The court may, like, institution of suit is one thing where we wanted to make some changes, but once the case actually started, after that also we may want to make certain changes in the plaint or in the written statement. Okay, so the court may, at any stage of the proceeding, once the proceeding has started, at any stage of the proceeding, court is having the discretion. Okay, the court may, the court, it's not saying court shall, so court is having the discretion to take a decision here. The court may allow either party, whether plaintiff or the defendant, court may allow either party to alter or amend his pleading in such manner and in such terms as may be just. If the court feels that this is a proper ground, this is a valid reason based on which we can allow the party to make some changes in the pleading, that may be allowed by the court at its discretion. It may be allowed to either the plaintiff or even the defendant. And all such amendments shall be made as may be necessary for the purpose of determining the real question of controversy. It might make sense to make those changes because the proper question what parties wanted to decide, that is not being highlighted. In such cases, the court would allow that, okay, fine, you can make these changes in your pleading as well, provided that no application for amendment shall be allowed after trial has commenced. So usual rule is that once the trial has started, it should not be allowed. But again, court is having the discretion unless the court comes to conclusion that in spite of due diligence, like court is of the belief that no, it makes sense to allow the party to make these changes. It usually happens in case of Specific Relief Act. Okay, there is one legislation called Specific Relief Act where we have different types of relief available, like injunction, specific performance of contract. Okay, we have so many different types. Restitution of property. So in such cases, it may happen that party is claiming for something, but court feels that no, you could have asked for even more, even a better relief is available, or might be some alternate relief is available. In such cases, court is having the discretion. Even after the trial has started, court can say that you make these changes. You are simply asking for specific performance, but you can also ask for damages or compensation. That also will be provided to you. Or might be you have asked for this much compensation, you should actually ask for this much compensation. Okay, so whenever court is of the opinion that it makes sense to allow the party to make these changes, court can allow that as well. This is clear, right?
Yeah.
So these are like general rules which should apply when it is filed. Failure to amend after order.
All are part of section 26. Right?
Actually, Yeah, so these are related to this only, right? Institution of suit. These might be at a later stage also, or just at the starting also. Okay, so these rules
Okay.
are also relevant, so that those are we are discussing. Okay, and also related to those, some other rules are there. That's why the important ones we are discussing, like failure to amend after order. It is something a little bit different as compared to institution of suit, but still because it's related, we are doing that part. Okay, failure to amend after order. So if a party has taken this order for leave to amend and does not amend it, okay, court has allowed that, okay, fine, you can make the changes. And court has given some time that you have might be 15 days of time, make the changes and submit this amended copy. But the party did not do it. Or might be court did not mention a time frame, so within 14 days party has not made the changes. Okay, in such cases, the person should not be permitted to amend after expiry of this reasonable time. It will not be allowed that you can again like make changes, but there also again discretion of court is there. If court feels that, okay, fine, maybe party was having some valid reasons, in such cases it may be allowed. Might be party was given 14 days, just after that day lockdown was announced, court would assume, right, that okay, there is a valid reason, you can again like time may be extended. So those discretions are given to the court just to ensure that whatever decision is being taken, like whatever steps are being taken by court are justified. So all these were important rules from order 6. Okay, then we have order 7 also, where again we have some important rules related to plaint, which will be filed by the plaintiff. Now we are talking about plaint, that plaint should be submitted, that is how they need to institute the suit and everything. But what will be mentioned in the plaint? Okay, plaint, when at the starting it will mention in the before the so and so court. Okay, it will mention court name in which the suit is brought. See, in the court of so and so, court's name will be mentioned. That is what the format is also. So it will mention court name in which the suit is brought. It will mention name, description, and place of residence of the plaintiff. It will mention their names, their father name, address, age. It may even mention their profession. All those details will be given there. Name, description, residence, and place of residence of defendant, so far as they may be ascertained. If we are aware who all are our defendants, what are their addresses, everything, whatever we know, those details we would provide. Sometimes it may happen that we are not having much details of the other person. It may be that usually in case of theft, we see party's name will be there versus unidentified, as in we don't know who committed the crime. In case of civil suits also, it may be that from some company or agency, a person just entered our house, it's a trespass, but we don't know who that person is. Maybe we simply know that person's name or something. Whatever details may be ascertained, that we would provide for the defendant as well. Where the plaintiff or the defendant is a minor, a person of unsound mind, a statement to that effect. Usually it would be mentioned minor. For minor, it would be mentioned. Same ways, if a person is of unsound mind, that also has to be mentioned. The facts constituting the cause of action and when it arose. We need to mention the date, time, when it happened, where it happened, what happened. The details, we need to narrate the story. Facts showing that the court has jurisdiction. Jurisdiction is very important. If the court is not having right jurisdiction, court will straight away dismiss the case. That is why when you see a plaint, it will also be written that this has happened and this certain court is the right court having jurisdiction. Like it will be justified that because of these two reasons, you are the right court having the jurisdiction. So this case is filed before you. The relief which the plaintiff wants to claim, like we saw in the starting of the class also, 4 things are present: relief or the remedy that the person is asking. whether it's compensation, whether it's some order, whatever it is, that also will be mentioned in it. Where the plaintiff has allowed a set off or relinquished a portion of his claim, the amount so allowed or relinquished also. Sometimes what may happen is, this is what entire thing has happened, but I'm just leaving this part. It's fine, I don't need this thing, but I am concerned with this thing. So it also has to be clearly specified. Sometimes it may be said that, okay, I had given 5 lakhs rupees to this so and so person, and the person said he will return it along with interest, along with 20% interest in next 1 year. Now the person is in a very bad financial state. The person lost his job and stuff. So, okay, fine, I don't need the interest part, but I want my main, this thing, right? The main amount I want, principal amount I want. So that also has to be mentioned. If something you are just relinquishing, that part also you will mention. Whatever things remaining that you are claiming, that also has to be mentioned properly. A statement of the value of subject matter of the suit for the purpose of its jurisdiction and of court fees so far as the case admits. So we will also mention the like based on the subject matter, based on what happened, we would also mention value of the suit, because that also again helps to determine jurisdiction, like we saw in yesterday's class, right? The amount or valuation, suit valuation, based on that again jurisdiction is fixed, so that also will be indicated. So plaint as such should have all those initial details which are needed for starting of a case. Once the case starts, after that all the minute details and everything would come, but this is like the basic things which should be provided in the plaint. Okay, this is clear, right?
Yeah.
So this is how it is. The court name will be mentioned, so and so party, it is plaintiff. Whatever other details we have, age, residence, occupation, we would provide, versus so and so person. Then description of the parties in the particular case, what has happened, what thing has happened, everything will be given in detail. And just to ensure that these are filed in the like same sort of format, these appendix or forms are also been provided.
And like, is there any particular rule which, especially in terms of the template in between civil and criminal suits?
Yeah, like because CPC is just applicable in case of civil suit. So for criminal, we have CRPC.
No, in terms of if we see the case being filed, by looking at the case filed, can we make out, is there any, like if this is criminal case,
like as in case, like looking at this glance, first, yeah, you would be able to say by looking at this initials I said, right? If it is OS, that indicates it's an original suit. It has to be a civil suit only.
Okay.
For complaint, it would be like it will usually be like CS complaint, CC complaint case. It may be NA, NCT, that means negotiable instruments case. It may be CRM, criminal miscellaneous, like that. All these initials will indicate what case it is. Okay, next is grounds of exemption from limitation law. Now we know that Limitation Act is there. It's very much important, very much relevant for the purpose of this procedural part. It says grounds of exemption from limitation law. Limitation law is there, it is applicable, but are there any grounds based on which we can ask for an exemption? So where a suit is instituted after expiry of period which is being prescribed in limitation law, the plaint shall show the ground on which exemption is claimed. Usually people would file for condonation of delay. People would say that this is the reason why it got delayed. And if it's a valid ground, court would also accept it. So the party will also mention, if there is any ground, mention that this is what has happened, because of this reason it got delayed, and it may be accordingly exempted, that okay, fine, even though it got delayed, that is completely fine, we are excusing it. Next is relief to be specifically stated. Relief is very much important, because with the intention of getting that relief only, we are doing this entire process. We are filing the case, instituting the suit. So it's very much needed that relief is specifically mentioned in the plaint itself, because we have different types of reliefs available. In each type also, what exactly are we claiming for? If it's compensation, how much compensation are you claiming for? So it becomes very much important that it is specifically stated or mentioned in the plaint itself. So every plaint shall state specifically the relief which the plaintiff claims, either simply or in alternative. We may either mention that this is what I want. Simply, I want compensation of this much amount. Sometimes we may also mention alternative relief. We may say, if possible, provide for specific performance of the contract. Ask this person to perform the contractual obligations. But specific performance might not be possible in each case. So in alternative, if it's not possible, in that case, give me this much amount of compensation. Okay, so whatever is applicable depending on the case, we would give an idea to the court that this is what I want. That is the reason why I'm filing this case. Provide me this or this. Okay. Okay, so these are the important parts which we have from these three orders, order 4, 6, and 7, relating to institution of suits. Okay.